Hare Krishna. Welcome to Tax Guru YouTube channel. This is CA Rohan R. Pingale, practicing chartered accountant based in Mumbai, also partner in Motilal and Associates LLP, member firm of Marks Network. And today I'm going to conduct a special video on a subject which is validity of notices issued by jurisdictional assessing officer instead of faceless assessing officer. So it is very important. Just let's dive into it directly. Let me allow to share my screen. Yes. So today's our topic is validity of notices issued by jurisdictional assessing officer instead of faceless assessing officer. So, and that is covered in faceless assessment and reassessment proceedings. And we will going to see judicial trends, legal analysis, and practical strategy. So this is a coverage of today's topic. So let's start. Today's session deals with one of the most litigated and impactful issues under the faceless regime, whether notices or order issued by jurisdictional assessing officer instead of the faceless assessing officer are legally valid or not. Okay, the issue is not procedural, but going to be the jurisdictional issue and has led to annulment of thousands of assessments and reassessments across the country. So why this issue is important? Let's understand why this is important. Because massive litigation under faceless regimes are going on. Entire proceedings may become void if the issue was root to the jurisdiction. It applies to section 143 subsection 3, section 147, 148, section 148A. Then jurisdictional issue is not a technical lapse. It goes into the root of the cause. This issue is a critical because if the authority issuing the notice, okay, it is important and critical because if the authority issuing the notice lacks, if it is lacks jurisdiction, the entire proceedings will get collapse. It affects what? Regular assessments, reassessments, and also pre-reopening notices under section 148A. So members must identify such defects at the earlier stage to protect our taxpayer rights. Very important. So we need to identify such defects at very early stage of the assessments to protect our clients' rights. Next. What is the objective of the faceless regime? Let's understand that too. What is the objective of faceless regime? It's a transparency, accountability, reduced discretion, elimination of territorial biases, shift from territorial to functional jurisdiction. Very important objective. It is shifting from territorial to functional jurisdiction. Faceless regime was not merely a technological reform. It fundamentally changed how jurisdiction works. Earlier, jurisdiction was what? Territorial. And under faceless regime, jurisdictional it turned to the functional, means determined by automated allocation, no manual intervention at all. This shift is the root cause of the current controversy, means from jurisdiction to functional. This shift, jurisdiction to functional, means it this shift was a root cause of the current controversy, means from territorial to functional jurisdiction. Next, key authorities, that is jurisdictional assessing officer versus faceless assessing officer. So jurisdictional assessing officer carries what? Territorial jurisdiction, traditional law, limited functions, post-faceless regime. And faceless assessing officer, automated allocation, functional jurisdiction, core assessment powers. So once faceless regime applies, okay, once faceless regime applies, the traditional jurisdictional assessing officer doesn't automatically retain authority. Means once the faceless regime applies, we note it is that traditional jurisdictional assessing officer doesn't automatically retain any authority. The faceless assessing officer FAO, though not territorial linked, becomes the legally empowered authority for assessment and reassessment functions. Once we in faceless assessment, then FAO, though not territorially linked, becomes the legally empowered authority for assessment as well as for reassessment functions. Next, section 144B. Let's understand faceless assessment. Mandatory faceless assessments means automated allocation, prescribed procedure, and word used here is shall. Okay. In earlier section 144B subsection 9, assessment otherwise than in accordance is what non-est. Okay. It was earlier. Means section 144B leaves no discretion. Very clear. It leaves no discretion. It uses mandatory language like word shall. Earlier subsection 9 categorically stated that any assessment not following the faceless procedure, any assessment not following the faceless procedure would be non-est in law. This provision formed what the backbone of early judicial decision quashing the assessments outright. Next, faceless reassessment framework. Let's understand faceless reassessment framework. Finance Act 2021 overall. Introduction of Section 148A, Faceless Reassessment Scheme, and Faceless Assessing Officer, that is FAO, performs what? Core reopening the functions. Post 2021, reassessment is a tightly controlled process. Post 2021, reassessment is a tightly controlled process. Notices under Section 148 and show cause notices under Section 148A clause B are required to be issued through the faceless mechanism only. Jurisdiction of assessing officer's role is peripheral and not foundational. Let's understand the core controversy now. Can a notice or order survive if issued by jurisdictional assessing officer when faceless regime applies? Common situations we come to across are 148 notice by JAO, 148A clause B show cause notice by jurisdictional assessing officer, reassessment order by jurisdictional assessing officer, mixed FAO JAO involvement. So the central question courts are addressing is whether a notice or order issued by an officer who lacks authority under the faceless regime can be sustained. Very, very important. Means this is the central question that court is addressing. Various factual permutations have arisen and each tested judicially. Means each of these cases need to be tested judicially and separately. So jurisdictional error versus procedural lapse. Let's understand the jurisdictional error versus procedural lapse. What is jurisdictional error? Authority lacks power, void ab initio. If it is a jurisdictional error, it would become effect of void ab initio and not curable at all. Let's understand procedural lapse. Authority competent, very much. Process defective and can be curable. Very important. It can be curable. Means it is a related if it is a procedural lapse. Okay. And if it goes to the jurisdictional error, then it cannot be a curable and it can be a void ab initio. So this distinction is what fundamental. If jurisdictional assessing officer lacks jurisdiction, I'm emphasizing on this word. If jurisdictional assessing officer lacks jurisdiction, the defect is incurable. Section 292B cannot save such action. Most high courts have treated jurisdictional assessing officer issued notices under faceless regime as jurisdictional defect. And if it is treated as jurisdictional defect, it goes into the root of it. It is not curable, and whatever assessment based on that will become void ab initio. So already most of the high courts have treated the JO issued notices under faceless regime as jurisdictional defect. So early judicial approach was is faceless scheme is mandatory. Jurisdictional assessing officer has no authority. Actions held void and no remand granted. In the initial phase, courts took a very strict view. Since Section 144B subsection 9 declared non-compliant assessment as non-aged, courts quashed them outright without giving even revenue a second chance. Let's understand Section 144B subsection 9 amendment. Finance Act 2022 amended this word non-est removed. Revenues argument was it is a procedural lapse and Section 292B will be applicable. The amendment was introduced to what? Mitigate the revenue loss from the department point of view. The department now argues that the deviation from faceless procedure is merely what? Procedural lapse. So that it will be a curable whatever the issue we are coming in. So the department argues that deviation from faceless procedure is merely a procedural. It is not a jurisdictional. However, courts have clarified that amendment, whatever amendment is done, is doesn't confer the jurisdiction where none exist. So very, very, very important. Let's see post-amendment judicial view. What is the post-amendment judicial view? Authority is still examining. Applicability of faceless regime is tested. Lack of jurisdiction remains what? Fatal. Still, the jurisdictional error is a fatal one. So post-amendment courts look deeper. If faceless regime applied and jurisdictional assessing officer had no authority, proceedings are still can be quashed. The amendment doesn't validate the actions of an incompetent authority. When one cannot ratify that amendment cannot ratify the actions of an incompetent authority. Means it's root to a jurisdiction issue. So next, faceless reassessment, stricter scrutiny, reopening of its vested rights. Courts more stringent 148, 148A notices by jurisdictional assessing officer often are going quashed. So reassessment cases face stricter scrutiny because they disturbed what concluded assessments. Means one has to be very careful. Means reassessment cases are seen as a stricter scrutiny because they disturb what already concluded assessments. Courts have repeatedly held that jurisdictional assessing officer issued reassessment notices under faceless regime are completely invalid. Please note down, courts have repeatedly holding that jurisdictional assessing officer issued reassessment notices under faceless regime are invalid. So let's move on. Revenue defenses and court response to it. Section 292B rejected. Participation by assessee irrelevant. No prejudice not applicable. Means still the revenue is defending its stand. It means participation by assessee altogether that, but court is saying that it is irrelevant. Means even though assessee or client has participated in that issue, it is irrelevant. So revenue commonly argues that assessee participated or prejudice or no prejudice occurred. Courts consistently holding that the jurisdiction cannot be waived, and prejudice test doesn't apply here to jurisdictional defects. Means if it is a jurisdictional defect, then prejudice test doesn't apply at all. Practical strategy for us. What is the practical strategy for the members? So this jurisdiction objection we need to raise very early, separate from merits. Ground number one of our appeal should be this: seek annulment and not set aside. Means we need to raise a jurisdictional objection at the very early stage of the assessments and maintain them separately from the merits. And in appeals, always seek what? annulment of the proceedings rather than remand. And we this need to be our ground number one of the appeal. Let's see few of the case laws illustrative examples. Means Hexaware Technologies Limited, Bombay High Court; Siemens Financial Services, Bombay High Court; Harbanshal Malhotra, Delhi High Court; Kalpesh Synthetics, Gujarat High Court; then Sutherland Global, Madras High Court. These all cases consistently holding that notices issued by jurisdictional assessing officer under faceless regime are invalid due to what? Lack of jurisdiction. Members should rely on jurisdictional high court rulings wherever possible. If please take if you want, take the screenshot of the slide, so that these are the case laws which give us the provide us the principle that the notices issued by jurisdictional assessing officer under faceless regime are invalid due to what? Lack of jurisdiction. But even though members should rely on jurisdictional high court rulings wherever possible. Let's see important clarification on Ashish Agarwal case. This Ashish Agarwal judgment. Let's see. Transition relief case doesn't validate jurisdictional assessing officer jurisdiction limited to old reassessment regime. Means Ashish Agarwal judgment is often misquoted. It doesn't approve JAO action under faceless regime. Be remember that. It only provided a one-time transitional solution. Now, let's move on to the key takeaways from today's this topic from today's learning. Faceless regime changes what? Jurisdiction. Means from territorial to the functional. Very important. What? Faceless regime changes the jurisdiction from territorial to functional. Jurisdictional assessing officer not equal to faceless assessing officer. They are completely at a different footage, different ground. Authority matters more than the procedural. Means that is the it root is a the error, or means authority matters more than what a procedural. Jurisdictional error strike at the root of it. The faceless regime is a jurisdictional revolution. When jurisdiction shifts, authority must follow. Any deviation is not a mere technically, it goes to the root of the legality. And now to the concluding remark is faceless regime is not optional. Okay, jurisdiction must follow the statute. As professional, our duty is to identify jurisdictional lapses and protect our taxpayers' rights. Faceless regime demands what? Strict statutory compliance and nothing less. That's it for today. Thank you so much for patient hearing. And if you want any suggestion, want to give some suggestions, observations, and any queries related to, you can connect with me. Please note down my contact numbers, my email ID. You can text to this number. It is on available also on WhatsApp. You can mail to me, and keep connected to the TaxGuru YouTube channel. If you are not yet subscribed, then do subscribe TaxGuru YouTube channel for latest updates like this and latest videos on the topic, very hot topic like this. So stay tuned to the TaxGuru YouTube channel. Thank you so much. Bye bye. Take care. See you soon. Hare Krishna.